is in the matter of the people of the state of Michigan versus Christopher David Lake. Let me grab your file. I have Rhonda Underwood appearing on behalf of Mr. Lake. I have Christopher Fleming here on behalf of the people, and Miss Holly is here from the Michigan Department of Corrections. Miss Underwood, I show that this sentencing has been adjourned. Well, this will be the fourth time set for hearing. So Miss Underwood, how would you like to proceed today?
Your Honor, Mr. Lape has a preliminary examination scheduled within the next 2 weeks downstairs. So I would like to, I spoke with Mr. Lape. I would like to adjourn this to after that, Your Honor.
Ms. Teskey, did we ever review him for drug court?
Let me look, Your Honor.
I think he never showed for sentencing, so they may not have.
Oh, probably.
That is correct. We weren't able to get a hold of him.
Okay, all right. So my next available pretrial conference is September 6th at 8:30 in the morning. Miss Underwood, if you feel like you have a resolution and he comes upstairs on his new charge, if you can just give Miss Adams some notice, she will put the files over together.
As I've explained to Mr. Lape, Your Honor, I can call the court and make an appointment to get him into court when we need to do that.
Okay, all right, Mr. Lake, I will see you back on September 6th at 8:30 in the morning. Thank you, if not sooner. Thank you.
Thank you. That's all I had.
All right, thanks, Ms. Holly. All right, I have John Glazier represents somebody.
Darius Jackson, I think.
Who?
Darius Jackson.
You talking about Derek Jackson from MDOC?
Yeah, it must be who it is. I got the first name wrong.
Well, I did appoint the public. All right. So we already called that case because the attorney was here from Sato.
Okay.
And he did request court-appointed counsel.
Okay.
So I did appoint counsel or the Lenawee County Public Defender's Office.
Okay.
And then I set it over to September 6th at 8:30 in the morning.
Okay. At what time did you say? 8:30?
Yes, sir.
All right. Thank you.
All right. Thank you. All right, Mr. Noe. You have Jackie Smith from the jail. So. I don't know, I got 2 jail windows. I'm pretty excited. All right, Mr. Lambert, let me grab your files. So this is in the matter of the people of the state of Michigan versus Randall Allen Lambert. We have file number 21-20501FH. We have 21-20500FH and 21-20499FH. I have Rhonda Underwood appearing on behalf of Mr. Lambert. This is the date and time scheduled for a probation violation hearing. Miss Underwood, how do you wish to proceed today?
Your Honor, I spoke with Mr. Lambert yesterday, but our meeting was cut short. So could I just have a brief breakout with you, please?
Of course, of course. All right. So, Mr. Lambert, I'm going to open up a breakout room for you and Miss Underwood. And either, yep, you might have to join it. Okay. All right, I have another gentleman from the jail. What is your name, please?
Aaron Powell.
Aaron Powell. Okay.
Yes.
Mr. Noe, I'll put your client on the list to be brought next.
Judge, I believe we asked for Stephen Powell. No, I'll run that name.
Oh, what's your first name?
Aaron,
Well, Aaron, I don't need you. I need Stephen Powell.
okay,
But it was nice meeting you.
yep.
Poor kid wanting to get a felony. Like, oh my gosh, why am I so
That's cool. Don't need me. I need Steve.
Yeah. All right, I'll close that breakout room with Underwood. Bring him back. There we go. All right, so Miss Underwood, have you had enough time to speak with Mr. Lambert this morning?
Yes, Your Honor.
All right, and how would you like to proceed on behalf of Mr. Lambert?
I believe Mr. Lambert wishes to accept the responsibility for his failure to report, Your Honor.
Okay, so Mr. Lambert, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? So, Mr. Lambert, you're in a room that has pretty bad audio,
Yes,
so
ma'am.
can you speak up?
Yes, Your Honor.
Okay, all right, so you put your hand down. So, Mr. Lambert, we're here on 3 files today, and on each of these files, it is alleged that you have violated the terms of your probation in that, hold on, you failed to, notice. Okay, so we have a couple things. We have a contempt of court for failure to appear for a probation violation hearing on July 5th of 23. But then, Ms. Teskey, we still have the underlying violation of probation as well, correct?
Yes,
Okay, and then that date was the date and time set for hearing on the violation that alleges that you failed to report to probation as often as required, in that, in fact, you failed to report on June 20th of 2023 or any time thereafter. So do you understand those are the allegations against you?
Yes, I understand.
Okay, so Mr. Lambert, you're on file number 21-20501FH. You are currently on probation for use of methamphetamine, which carries a maximum penalty of up to 1 year in jail. And on file number 21-20500FH, you are currently on probation for police officer fleeing 3rd degree, which carries a maximum penalty of up to 5 years in prison if you plead guilty or found guilty. And then on file number 21-20499FH, you're currently on probation for motor vehicle unlawful driving away, which carries a maximum penalty of up to 5 years in prison if you're found guilty or plead guilty. Do you understand that, sir?
Yes, Your Honor.
Okay. Now, are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, I'm satisfied.
Good. And do you understand that you do have a right to contest the violation of probation charge and have a trial on it? Do you understand that?
Yes, yes.
Okay. Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, I understand, Your Honor.
You have a right to have all the witnesses against you appear at your trial and have your lawyer ask those witnesses questions. You may ask them yourself, and you may also have me order any witnesses you might have to appear at that trial. Do you understand that?
I understand, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, Your Honor, I understand.
Okay, so how do you plead to the charge? One, on the contempt of court, that you failed to appear for hearing on a violation of probation on July 5th of 23. Guilty or not guilty?
Plead guilty. I don't know how to do this.
Hold on,
Psychologically.
hold on. I'm just asking you to say guilty or not guilty at this point. And then how do you plead to the charge that you violated the terms of your probation by failing to report to your probation officer on June 20 of 23 or any time thereafter? How do you plead to that charge?
I plead guilty, Your Honor.
All right, so do you understand that by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes, Your Honor.
Has anything been promised you to get you to plead guilty?
No,
Has anyone threatened you in any way to get you to plead guilty?
no, Your Honor.
If I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yeah, I understand, Your Honor.
All right. Is it your own choice to plead guilty? Is it your own choice to plead guilty, Mr. Lambert?
Yes, Your Honor.
All right, so Mr. Lambert, you were on probation with Ms. Teskey, and she violated you and sent a request and summons for probation violation. And she alleged that on November 9th of 21, you were ordered to report to the probation department as ordered, and that you failed to report on June 20th of 23 or any time thereafter. And that violation is on each file. So how do you plead to the charge? Wait a second. So, all right. So when you were ordered to report to her on June 20th of 23, is that right?
Yes, I think so.
Okay.
I don't know if I never got a letter.
Mr. Lambert, you report on Tuesdays to Ms. Teskey, right?
Yes. Yes,
And
I'm having psychological issues. That's why
I understand that, Mr. Lambert, but I understand that. But my question for you is, you were ordered to report that Tuesday to Ms. Teskey, yes or no?
Yeah, most likely, yes. Yes, I was supposed to, yes.
Do you report to Ms. Teskey every Tuesday?
Yes. No, not every Tuesday, no.
What Tuesday of the month do you report to Ms. Teskey?
I think it went to once a month, I think, maybe at one night.
All right, was it the first Tuesday, the second Tuesday, the third Tuesday?
Second Tuesday? I can't
Okay.
remember, Your Honor.
Okay, if I were to tell you it's the third Tuesday of the month, would you agree with that?
Yes,
Okay, did you report to see Ms. Teskey in June?
no.
You didn't
No,
even come to drug court, did you?
Yeah, I don't remember coming back to a court.
Okay, and did you report to her in July?
I don't remember. I don't know. I don't think I did.
So you haven't reported to Ms. Teskey in almost 2 months, right?
Probably about a couple months, yeah.
Okay, now, a notice to appear for a probation violation hearing was mailed to your address that we have, and it ordered you to appear on July 5th of 23. Did you appear in court that day?
July 25th,
July 5th.
today, yes.
July 5th. So you didn't report to probation with Ms. Teskey, and then we show caused you, and you were supposed to come to court to tell me why you didn't report to Ms. Teskey on July 5th, but you didn't come to court on July 5th, did you?
No, I didn't, Your Honor.
And okay. All right, I accept the plea. It has been given understandably, voluntarily, and accurately on each file. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Underwood, are you available on August 3rd at 8 a.m. for sentencing?
That's fine, Your Honor.
All right, so I will set this for sentencing on August 3rd at 8 a.m. And Mr. Lambert, Ms. Teskey will come see you and she'll talk to you and she'll prepare a probation violation report. And then we will see you back on August 3rd at 8:30 in the morning. Mr. Lambert, do you have any objection to appearing via Zoom again?
No objections, Your Honor.
All right, so that'll be via Zoom. All right. Okay, thank you. We'll see you back then, Mr. Lambert.
Okay.
Thank you. All right. All right, Jackie Smith. So, Ms. Underwood, we're waiting on Stephen Powell.
That's it.
Stephen Powell, okay. And we didn't have any pickups. So, Mr. Noe, I do have Jackie Smith. Grab her file. Mr. Murphy, just so you know, Mr. Norton is present in the courtroom. All right, this is in the matter of the people of the state of Michigan versus Jackie Mae Smith, file number 23-21300FH. I have Charles Noe appearing on behalf of Ms. Smith. Ms. Smith is present from the jail. And I have Christopher Fleming appearing on behalf of the people. This is the date and time scheduled for a pretrial conference in this matter. Mr. Noe, how would you like to proceed today?
Your Honor, there's been an update from Mr. Fleming as to a resolution yesterday, so I was wondering if I could speak to Ms. Smith in a breakout session, please.
Sure. All right, Ms. Smith, I'm going to open up a breakout room and assign you and Mr. Noe to that breakout room. Okay. Okay, so, sir, you want to come up to the podium? Mr. Norton?
Oh, yeah.
Yep, come on up. We'll get you out of here. If I could get Stephen Powell from the jail.
Okay, Your Honor.
Thank you. All right, this is in the matter of the people of the state of Michigan versus Daniel Philip Norton, file number 23-21382FH. I am Matt Murphy appearing on behalf of Mr. Norton and Christopher Fleming appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So, Mr. Murphy, how would you like to proceed today?
Your Honor, my understanding of Mr. Norton's cases involves an offer from the prosecution that would be as charged to this felony file with no habitual offender notice, dismiss the misdemeanors. I have discussed that with my client. Again, that's what I have in my notes. This morning I was trying to figure out who is actually continuing on the case. So I contacted Ms. Meir and Ms. Wagner. I wasn't sure who it was. Mr. Norton is still wanting to discuss the case further with me. He does not want to accept that offer at this time. So I was going to ask for another pretrial and I guess just clarification from Mr. Fleming as to who I should direct my inquiries further for negotiations, I guess.
We have Ms. Wagner on the case.
All right, thank you.
All right. So, Mr. Norton, you're charged with larceny from a motor vehicle. That is a 5-year felony. So understand, because you have 1, 2, 3, 4, at least 4 prior convictions. Understand, if you were convicted at trial, you would be looking at life in prison.
Yeah.
Okay. All right. So, Mr. Murphy, my next available pretrial date, and Ms. Adams, because he's present in the courtroom, could I please get a notice for him? I'm going to set the next pretrial for this for September 6th at 8:30 in the morning. Mr. Norton, it's very important that you call Mr. Murphy's office and set the time to meet with him to talk about this so we can resolve this when we come back one way or the other. So, anything else, Mr. Murphy?
Nothing further, Your Honor. Thank you. I'll be in touch with Mr. Norton.
Okay. So, Mr. Norton, just have a seat on that bench behind you and we'll bring you out a notice of hearing, all right? Thank you, and we'll continue your mark. All right, Mr. Daly. Mr. Daly. All right, Mr. Murphy, I have a ton of your people. Mr. Daly, I showed that you represent Drew Levine. Are you retained or court appointed?
Court appointed.
Okay, that makes sense. All right, so I'm just waiting for the jail. So I think I have one more from the jail and then we'll take yours. So Mr. Murphy, I have Caitlin. No, I lost her now. Wait. Caitlin Whiteman. All right, Ms. Whiteman, this is in the matter of the people of the state of Michigan versus Caitlin Elizabeth Whiteman, file number 21-20579FH. I have Matthew Murphy appearing on behalf of Ms. Whiteman and Christopher Fleming appearing on behalf of the people. This is a date and time set for a pretrial in this matter. Mr. Murphy, how would you like to proceed today?
Your Honor, could I have a breakout session with my client to speak with her, please? The number I have is bad for, I guess, in my file.
Okay, so Ms. Whiteman, always make sure your attorney is updated on your phone number. I'm going to assign a breakout room to you and Mr. Murphy. Let's go ahead and join that breakout. Hello. You're not disconnecting my jail window, are you? No. Stay.
No, Your Honor, Stephen Powell hasn't been here in quite a while.
Oh, he's on the jail list.
I know, I was just trying to figure out why, and I'm not sure why he's on there. So that must be our mistake.
Okay, I appreciate that, but how about Drew Levine?
Sure.
Okay. Ms. Underwood, well done. So in the matter of the people of the state of Michigan versus Stephen Keith Powell II, file number 22-20907FH, 22-20908FH, 22-20911FH, 22-20912FH. Let me see here. Stephen Powell is, let me find his file number. This is the date and time scheduled for hearing on a probation violation. Oh, I'm sorry, Ms. Underwood. A request and summons for probation violation on each of these files was mailed to Mr. Powell on June 29th, scheduling it today for arraignment. Mr. Stephen Powell has failed to appear. I'm going to issue a bench warrant for his arrest, and I will set bond in the amount of $25,000 cash on each file.
Your Honor, prior to you doing that, I see this is just a technical violation that we received yesterday. Can I have just a second to dial the number we have from Mr. Powell's older files, I would assume, Your Honor, and see if I can get in touch with them?
Sure, I have no problem with that.
Thank you. I'll be back in just a second.
Not a problem.
I assumed he was in jail too.
Well, I think that's why I got the wrong Powell earlier. All right, Mr. Levine, let me grab your files. All right, Mr. Daly, this is in the matter of the people of the state of Michigan versus Drew Alexis Levine, file number 23-21429FH, 23-21430FH, and 23-21431FH. I have James Daly appearing on behalf of Mr. Levine, and I have Christopher Fleming appearing on behalf of the people. This is the date and time scheduled for arraignment, Mr. Daly, on each of these files. Do you waive the reading of the felony information?
Yes, Your Honor.
All right, and how would you like me to proceed on behalf of Mr. Levine this morning?
Not guilty.
All right, so the court will enter a plea of not guilty on each of these files. Mr. Daly, are you asking for a trial date to be set or another pretrial?
Your Honor, this is Mr. Sneed's case. Mr. Sneed and I had this matter resolved, and then these new files showed up, and that put a stop to our own negotiations. But I believe that we are still going to resolve this matter. Personally, I just as soon set it for a trial date and be ready to go to trial if it can't be resolved. But I do think it's going to be resolved.
All right, well, if you think it's going to be resolved, I'll set it for a pretrial conference. I don't have any jury trial dates really available until December, January, but
Right.
I'm gonna set it for a pretrial on September 20th at 8:30 in the morning. But Mr. Daly, if you work out a plea that Mr. Levine would like to avail himself of, you can just call my court and we'll get you in any other day than a Wednesday, all right?
Thank you, Your Honor.
All right, so I will enter a plea of not guilty on behalf of Mr. Levine. His bond is continued, and Mr. Levine, I'll see you back either on September 20th at 8:30 or even sooner. Bye, Mr. Levine.
Hi.
Okay, all right. So, Mr. Murphy, how would you like to proceed on behalf of Ms. Whiteman?
Yes, Your Honor. At this time, my understanding, the offer from the prosecution in this matter is for Ms. Whiteman to plead to possession of the taser and the domestic violence charge. At this time, we're asking to set a jury trial in this matter. I don't think it would take longer than a day for the trial to proceed.
So the plea offer is plea to possession of a taser and 1 count of domestic violence.
That was what I had in my notes. Yes, Your Honor.
All right. Okay, and take care of that. All right, so possession of taser is a 4-year felony. Domestic violence is a 93-day misdemeanor. Okay, assault with a dangerous weapon, so Alan Whiteman, okay. All right, so the domestic is tasing. Okay, got it. All right, so one day, are you asking for a jury trial or a bench trial?
Jury trial, Your Honor, please.
All right, Miss Adams, I'm looking for a December trial date.
Okay.
And if you wanted to bring me the book to relieve yourself of that, that's fine, but I don't think, well, I'll need it really today.
How many days did you say?
Just one.
Tuesday, November 14th is day 2 of a civil trial.
No, let's go another day.
I will figure right.
I'm sorry. It's just like, I'm not sure what this is. Well, that just means I gotta go into my hair and start till 9. Okay. Can I do that next? All right, Mr. Murphy, November 21 at November 21 at 9 a.m.
That should work for myself, Your Honor. Thank you. For the defense.
All right, so I will set this for trial on November 21 at 9 a.m. And I will do a final pretrial on November 1. And I will also make that the deadline for all motions, jury instructions, and voir dire questions. And then also make that the pretrial date at 8:30 in the morning. So I filled out a scheduling order. Okay, now we'll get a copy of that scheduling order out to you. So, Ms. Whiteman, make sure you stay in contact with your attorney. Make sure that you provide any phone numbers or addresses if you move or change your phone, okay?
Yes, ma'am.
All right, thank you, Ms. Whiteman.
Thank you.
Thank you, Your Honor.
Thank you. Okay,
Your
so,
Honor?
yes, Ms. Underwood.
I was not able to reach Mr. Powell. I did leave a message on voicemail.
All right, well, I'll continue the bench warrant on each file with a bond of $25,000 cash on each file for the value to appear. All right, Ms. Underwood, as always, thank you so much. All right, Mr. Noe, with regard to Ms. Smith, how would you like to proceed with Ms. Smith today?
A couple things, Judge. I've discussed this matter with Mr. Fleming and also discussed this matter with my client. We'd like to do one or two things, or two things actually. First, we'd like to get a new pretrial date from Ms. Smith, probably in, I'd say 30, 60 days or so. She has an out date on her violation, not till December 26th. So I'd like to have some more time to talk to Mr. Fleming and see where things are at. The other thing I'd like to do is Ms. Smith is currently on a PR bond on this matter. I'd like to put a $100 bond on her today as well.
Okay. All right, so I will set a pretrial in this matter for September 13th at 8:30 in the morning. And you said she has a PR bond on this file?
Yeah, I'd like to put a $100 bond on her, please.
All right, any objection to that, Mr. Fleming?
No objection, Judge.
All right, and I will put $1,000 cash assurity bond on this file. And Ms. Teskey, do we have violations of probation floating out there?
We dealt with those last week, Judge.
Okay, that was like a long time ago. All right, Ms. Smith, we'll see you back on that day. Mr. Noe, can you do the stip in order to adjourn?
Yes, Mr. Fleming, may I sign with your permission, please?
Absolutely. Thank you.
All right, thank you, Ms. Smith.
Thank you, nothing further. Yeah, Jackie, it was September 13th at 8:30, okay?
All right, so let's see, a bunch of people in the waiting room. Mr. Noe, I think that's all I have with you today.
Yep, Judge, that's it for today. You're stuck with me all day tomorrow, but you are done with me for today.
Okay, looking forward to it. Thanks.
I'm sure you are. Thank you. Have a good day.
All right, Mr. Murphy, Jeremy Vasquez.
I'm ready to proceed on the record.
He's not here.
Oh. I'll give him a call.
Miss Adams, could I get Timothy Merritt from the jail, please?
I did it in a federal. First form's already gone, so I already gave. Once you throw your left way and then that is your first one.
Mr. Murphy, any luck?
Not on Mr. Vasquez. I mean, I spoke with him,
Okay.
I know.
You what?
Last I spoke with him was at the exam when we waived. I don't recall if I spoke with him before then or after then before now, so
Did you mail a copy of the, well, I guess,
Well, that's, I mean, I think that comes from the courts. And I don't know if we received.
okay, that would have come from district court. All right, so in the matter of the people of the state of Michigan versus Jeremy Enrique Vasquez, file number 23-21434FH, and Matthew Murphy appearing on behalf of Mr. Vasquez and Christopher Fleming appearing on behalf of the people. I do show that an examination waiver form listed today's date as the date to appear in circuit court. Mr. Vasquez has failed to appear. I'm going to issue a bench warrant for his arrest, and I'm going to set bond in the amount of 10,000 cash. Mr. Murphy, if you hear from him, just let us know. I hold the warrant for 2 days. And we will have him brought in, okay?
Yes, Your Honor. Thank you.
All right, thank you. So let's move on to your next one. I have, okay, so it's Mr. Malaro. Mr. Malaro. Where am I at? I know I have another one. I'm waiting for Merritt from the jail. If I could get Timothy Merritt from the jail, and then I have Joseph Johnson. And you have Bridget Reinhardt as well.
I do not, Your Honor.
Hey, what's happening, Mr.
Who said that? What was that? Oh, Mr.
That was my
Johnson.
client,
Hi.
Mr. Johnson.
All right, so this is in the matter of the people of the state of Michigan versus Joseph Anthony Johnson. We have two files, 22-21089FH, 23-21344FH. I have Mr. Johnson zooming in. I have Christopher Fleming appearing on behalf of the people and Matthew Murphy appearing on behalf of Mr. Johnson. This is the date and time set for a pretrial in this matter. I have received a copy of the prosecution's jury instructions, list of witnesses, charges, and verdict form. And let's see here. Oh, what is this? All right, so this is also a date and time set for contempt of court hearing. I have in my file a report stating that Deputy Anthony Esposito on June 15th of 2023 at 1:29 hours conducted a traffic stop on an individual with the initials AC and observed Joseph Johnson sitting in the passenger seat of the vehicle. That individual is a victim of the domestic violence that he's charged with. There are bond conditions that he is not to be in her presence. So, Mr. Murphy, how would you like to proceed today?
Your Honor, I messaged Mr. Sneed in regard to this case. And I think he had agreed, I'm not sure if it was put in the notes, that Mr. Johnson could plead on the felony file, which I believe there's two of them, to attempted R&Os, one on each file, with no upfront jail. And there's misdemeanor files that are in district court that are separate, that would continue along separately. Again, that's what I spoke about, or I messaged Mr. Sneed this morning. I'm not sure if Mr. Johnson wants to accept that now or not, but I did want to ask if we could possibly address the bond condition of no contact. Mr. Johnson, did you want to accept that offer now, or do you want to set this for trial?
Well, I will tell you that without the victim here and input, I cannot address that bond condition.
Your Honor, all I wanted to place on the record was what Your Honor had placed on the record previously, which was that the circumstances involving the contact was that he was in the vehicle. There was no allegation from the victim.
I understand that. I understand, Mr. Murphy, but I don't think I have the authority to release bond conditions on a victim crime without input from the prosecutor and the victim advocate. I mean, obviously, whatever happened at the last hearing is not in jail, so I did take that into account.
Yes, Your
I
Honor.
mean, it's fairly simple. All she needs to do is contact or set it for hearing and have her appear. Mr. Fleming, do you have any information from that individual?
I don't, Judge.
So the plea offer is to plead to 2 one-year misdemeanors, so the felonies would be dismissed. He has no prior felonies on his record, so that's the reckless would be dismissed, the domestic violence up here would be dismissed. I don't sign a dismissal to the date of sentencing, and so unless you motion in bond conditions, those would remain. Oh yes, 2 domestics with her. So those would get dismissed at the time of sentencing, but you could always file a motion and then the people could meet with her and discuss whether or not to change those bond conditions. So Mr. Johnson, so the plea offer is to 2 one-year misdemeanors and dismissing all the felonies, including these 2 domestics. Are you, Mr. Murphy, what do you want to do?
Oh, well, I spoke with Mr. Johnson previously about this. I didn't know if we want to take that off or just set it for trial. Do you want to talk to me in a breakout, Mr. Johnson, or do you know your answer right now?
Oh, it's okay. I'll accept that. I'll accept the plea.
All right. So Mr. Fleming, there's going to be an added count 4 attempted RNO on file number 22-21089FH. Is that correct?
That's correct, Judge.
All right. And then on file number 23-21344FH, there'll be an added count 3 attempted RNO. All charges will be dismissed at the time of sentencing, and he has no habituals. So is that a correct recitation of the plea, Mr. Fleming?
It's all remaining, Judge. Not all charges will be dismissed, but all remaining will be dismissed.
In circuit court.
Yes,
circuit
2
court
cases
charges.
in district that are separate. I wanted to make sure
Right.
Mr. Johnson understood that. I talked about it before, but those are separate from this.
Okay, so Mr. Johnson, do you understand, while I have a couple of domestic violences up here that will be dismissed, you have some other cases in district court that are misdemeanors, and those are not mine and won't be dismissed. Do you understand that?
I do, Your Honor.
Great. Want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, will you state your full name for the record?
Joseph Anthony Johnson.
Okay. And Mr. Fleming, can you make sure we get a copy of the amended information today? You always do. I'm just reminding.
Absolutely. Just requested them now.
All right, thank you. All right, so Mr. Jensen, you heard the statement of your attorney, the prosecuting attorney, and myself. Is your intention on file number 22-21089FH to plead guilty to an added count 4, attempted resisting and obstructing a police officer?
Yes.
Yes. All right, and then on file number 23-21344FH, is it your intention on that file to plead guilty to an added count 3, attempted resisting and obstructing a police officer?
Yes.
All right, are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Absolutely.
Now, do you understand the maximum penalty for both of these offenses could be up to 1 year in jail? Do you understand that?
I do, Your Honor.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Fleming? You're muted.
That's correct, Judge.
All right, Mr. Murphy
That's correct, Your Honor.
and Mr. Johnson, is that correct as far as you're aware?
Yes, ma'am.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial, by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial. and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at the trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Johnson?
Yes, Your Honor.
And do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I have given to you, sir?
I do not.
All right, so I'll start with file number 2. All right, on file number 22-21089FH, Mr. Johnson, how do you wish to plead to the charge that on or about August 7th of 2022 in the village of Clinton in the county of Lenawee, that you did commit the added count for assault or attempted police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty.
Okay. And then on file number 23-21344FH, Mr. Johnson, how do you wish to plead to the charge that on or about March 16th of 2023 in the village of Clinton, the county of Lenawee, that you did commit the added count 2 offense of attempted police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel, I'm so sorry, aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fleming?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
So, Mr. Johnson, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Johnson, on file number 22-21089FH, get down there. On August 7th of 2022, were you in the village of Clinton in the county of Lenawee?
Yes, Your Honor.
Now, this one involves Officer Hillard. Do you know who Officer Hillard is?
I do.
All right, did you come in contact with Officer Hillard that day?
Yes, Your Honor.
And was he wearing a uniform that made it clear to you he was an officer of the village of Clinton Police Department?
Yes, Your Honor.
All right, now, did he pull you over on Church Street there in Clinton?
No.
Okay, were you driving a motor vehicle when you came in contact with him?
No, Your Honor.
Okay, were you walking down the street?
No, Your Honor.
Did he come to your house?
Yes.
Okay, so he came to your house and did he knock on the door?
No.
Okay, tell me at what point did you physically come in contact with him?
He came to, actually, I think he might have came to the door. I guess he saw me outside and he came to the door and asked me, or asked somebody else to come get me from inside. So I walked out and talked to him.
Okay, to go out and talk to him. Did you go out and talk to him?
Yes, Your Honor.
Okay, now, did he try to take you into custody that day?
He did, yes.
All right, and so you're charged with assaulting, battering, wounding, resisting, obstructing, opposing, or endangering him. So that could be anything from running away, pulling your hand away, refusing to put your hands out for handcuffs, punching him, kicking him, biting him. Tell me what you did to Officer Hillard that would constitute one of those.
Your Honor,
I'm
could
sorry,
I
I
have
think
a-
that,
Oh,
Hold
I'm sorry.
on, Mr. Murphy, hold on. Mr. Johnson,
I think I have two dates confused. Because I thought you were referring to the time that he picked me up when I hadn't done anything, but I was at the house.
well,
That-
I have an August 7th date with Officer Hillard, but then we have in March of 23, an incident that occurred with Chief Cuevas.
Okay, no, I'm sorry. I was referring to a different instant. The time you're referring to, I did not come in contact with Officer Hillard.
Your Honor,
Did
could I?
you, when you- go ahead, Mr. Murphy.
Just to make sure he has the dates correct. Could I speak to him in a breakout session just to make sure we're on the same page about the incidents and what the dates were?
Sure.
Thank you.
All right, Mr. Johnson, I'm gonna open up that breakout room. Put
Okay,
you back in. You're gonna have to join with Mr. Murphy. Okay, so I'm gonna sign Mr. Murphy and Mr. Johnson. All right, go ahead and join that breakout room.
Thank you.
Mr. Merritt, it'll just be a minute. You're next, okay?
All right.
Oh, Mr. Murphy, let me close that breakout room. Just remove it. All right, we are back with Mr. Johnson. Mr. Murphy?
Yes, Your Honor, thank you for that breakout session. And speaking of Mr. Johnson, he still wishes to continue with the plea. He doesn't want to set the case for trial. I didn't know if Your Honor wanted me to voir dire him in a factual basis.
That's fine. You can go ahead.
So, Mr. Johnson, again, we're talking about the first case from back in August of 2022. Officer Hilliard came to the house that you shared with the complaining witness in this matter, correct?
Yes.
Okay, and he was there in response to a phone call or a complaint about a domestic violence, from your understanding, correct?
Correct.
Okay, and he, you became aware that he was at the door speaking with the complaining witness, and you left out the back door, correct?
Correct.
Okay, and you knew that he wanted to speak with you, but you didn't want to talk to him that night, and you just left. That's all you knew, and you made no contact with him later that night, correct?
Correct.
Your Honor, I'm satisfied with the factual basis for that case. I don't know if Mr. Fleming is or not.
Mr. Fleming, I mean, running is running.
Did Officer Hilliard give you any direct orders not to run?
No, sir.
You didn't hear Mr. Johnson, you didn't hear Officer Diller give you any orders?
No.
Okay. But you were aware that he wanted you to talk with him though, correct? You're aware that he probably wanted to investigate some allegation?
No, really, honestly.
Okay.
I did not.
Well, Mr. Johnson, the police officer came to your house and asked to speak with you, correct?
That was at a different time he was referring to. He didn't actually he didn't talk with Officer Hilliard that night or that morning. He just ran out the back door.
But the officer came to the door and talked to somebody,
Yes,
and they asked to speak to Mr. Johnson.
yes,
So Mr. Johnson was aware there was a police officer at the door asking to speak with him.
is that correct, Mr. Johnson?
I didn't hear anybody talking. I just left.
Did someone come to you and say there's a police officer here who wants to talk to you?
No, Your Honor.
So how did you know there was a cop at the, hold on, how did you know there was a police officer at the door?
I knew there was somebody there. I didn't know who it was, honestly.
Okay, I can't accept the plea, so I can set this for trial.
Yeah, can we set up for trial, please, Your Honor?
This is the older file, so it would be set for trial first. It's an R&O, those usually take a day or less. So, Mr. Murphy, if you have, can we do a no contest? Do you wanna, I don't know, Mr. Fleming, I can set it for 1 day.
I just read the report. Can I voir dire real quick, Judge? We might be able to. On that August 8th date with Officer Hilliard, do you have security cameras at the house?
I do, sir.
And were you able to see the police officers arrive via those security cameras?
I was not in the room where the TV, where the monitor was, no.
Okay, and if Officer Hilliard indicated that he yelled at you to stop when you were running from the residence at 227 East Church Street, would that sound right to you?
I mean, I would assume that he did, yes.
Okay. And
I would assume that he did.
And you didn't stop when he yelled at you to stop, correct?
No, you're right. You're correct.
All right.
Are you satisfied now, Mr. Fleming?
People are satisfied now, Judge.
All right, so let's move on to 23-21344FH. So Mr. Johnson, on March 16th of 2023, were you at your home again in Clinton?
Yes, Your Honor.
And do you know who Chief Cuevas is?
Yes, Your Honor.
Did he come to your house?
No.
Okay, so did you come in contact with Chief Cuevas? Did he come looking for you? Tell me what happened on this one.
Yes, he came looking for me, I guess.
Okay, I get a lot of guesses. So Mr. Johnson, this is really important because if I don't accept your plea and you go to trial, then you go to jail. And so usually when people say, I guess, I don't know, probably they're trying to not acknowledge what they did. But on that day, did you have contact with Chief Cuevas?
I did, Your Honor. Yes.
Did you see him? Did you talk to him? How did you have contact?
He arrested me.
Okay, so he actually did have physical contact with you. So once again, we're pleading to an assault, batter, wound, resist, obstruct, oppose, or endanger. So when he took you into custody, did you do one of these things? Did you lie about your name? Did you pull your wrist away? Did you not give him your wrist for handcuffs? Did you not get in the car? Did you push him, pull him, kick him, bite him, kiss him? Like, what did you do that would constitute opposing a police officer?
I didn't do any of those things, Your Honor. I left, I was walking and he was pulling up in the vehicle and I kept walking. I kept going.
Okay, so did he tell you to stop?
I'm sure he did, yes.
Are you deaf?
What's that, Your Honor? I'm sorry.
Can you hear? Are you deaf?
No, I'm not deaf, Your Honor.
Okay, so did you see the police car pull up?
Yes, yes, I did.
Did you recognize it as being a Clinton Police Department vehicle?
Yes, Your Honor.
And Chief Cuevas, did you see him get out of the car?
No, Your Honor, I did not.
All right, unless you can help, Mr. Fleming.
We're on that date and time that the judge indicated. Were you at the football field behind the Clinton High School?
Yes, sir.
And you were walking across the football field when Chief Cuevas from the Clinton Police Department arrived, correct?
Correct.
And at that time, Chief Cuevas exited his vehicle and you took off running across the football field and jumped a fence, correct?
Correct.
And to your knowledge, did Chief Cuevas yell to that he was police and to stop?
I didn't hear him, but I'm sure he did.
Okay.
Would you agree that you knew that Chief Cuevas was probably there for you?
Yes, Your Honor.
All right, so when you saw him, you were like, nope, not going to jail today, and you took off.
Yes, Your Honor.
Okay, are you satisfied, Mr. Fleming?
People are satisfied, Judge.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Fleming?
Yes, Judge.
Mr. Murphy?
Yes, Your Honor.
I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to set this matter for sentencing on September 7 at 8:15 in the morning. That will be in person. So Mr. Johnson, I will need you to be present in the courtroom for sentencing. Now, I'm going to put you in a breakout room here in a moment with Ms. Teskey from the Michigan Department of Corrections. She's going to give you some instructions. One, there's a packet that you're going to get. You're going to have to come to the courthouse. She'll set up a time for that. You're going to get a packet. You need to fill the packet out. You need to return it to the probation department. And then they'll set up a time to meet with you. And it may very well be in person. And you're going to need to appear for that date. When you meet with them, be truthful about what happened. Be truthful with them about your background, the events that occurred, what you're doing in your life now to try to make sure this doesn't happen again. And we will see you back for sentencing on September 7th at 8:15. They'll prepare a pre-sentence report. We'll get a copy of that to Mr. Murphy. You need to meet with him or talk to him in advance of sentencing because I really don't have time to do breakout rooms on sentencing days. So when Mr. Murphy gets that, he'll call you to review that pre-sentence report and then make sure you keep your number updated with them and you get in contact with them about a week before if you haven't heard from them, okay?
Okay, Your Honor.
All right, so we'll see you back for sentencing on September 7th at 8:15. Ms. Teskey, can I put you in a breakout room with Mr. Johnson to get his information?
Yes, Judge.
Okay.
Thank you, Mr. Johnson. I'll be in contact with you, okay?
Okay, thank you, Mr. Murphy.
All right, so Mr. Johnson and Ms. Teskey, go ahead and join that breakout room, and then Mr. Johnson, you can disconnect and go on your way.
Okay, thank you, Your Honor.
Thank you. All right, Mr. Murphy, I have Mr. Merritt, and then I have another young man from the jail. What is your name, sir?
Jay Brown.
And who's your attorney? That's Mr. Malaro. I don't have Mr. Malaro yet. All right. So okay. Is DeAngelo Williams not the jail? Let's see. So, Mr. Brown, I apologize. I'm not ready for you yet because your attorney is down the hall. Could you tell them that I'd like to skip you and have Mr. Williams next?
Okay, thank you very much.
All right, thank you, and then I'll take you, okay?
Okay.
All right, get Mr. Merritt's files. All right, this is in the matter of the people of the state of Michigan versus Timothy Joe Merritt. I have two files, 20-20099FH and 23-21363FH. I have Christopher Fleming appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Merritt. This is a date and time set for pretrial in this matter. On both files, final pretrial on file number 20-20099FH. We are scheduled for a one-day jury trial on August 1st of 2023. I am going to presume, if you haven't already, witness or your questions, jury instructions are due today, as well as motions, which I don't have any. So the plea offer on file number 20-20099FH is plea to one count of police officer Arno, which carries a maximum penalty of up to 2 years in prison. The 4-year felonious assault would be dismissed, as well as the habitual offender fourth offense notice. And I never did get an offer placed on the record on file number 23-21363. That file has 2 counts of Arno and a habitual offender fourth offense notice. Mr. Murphy, how would you like to proceed today on behalf of Mr. Merritt?
Your Honor, there's been no change in the 2020099FH case, so we'll continue that to trial. I believe that's Mr. Sneed's case, and I will be speaking with him. If there's any change, we'll contact the court. In regards to the newer file, the 23 file, we just received the transcript on that last Thursday or Friday. I'm preparing a motion for that, and we'll have that submitted as soon as I can. So we
You
can
received that transcript for what?
the preliminary examination.
That was filed.
Yeah, we just received that. on Thursday.
Exam transcript. Well, hold on. I have one for November 30th of 2020. Was there another prelim?
Well, on the second file, the newer file, I'm saying.
Oh, on the 23 file. Okay.
Yeah. So again,
Mr. Fleming, is there a plea on that file that you see?
In the 23 file, Judge, no, we never had plea discussions. He just set it for an exam and we had the exam and it was bound over. In regards to the 20 case that's set for trial in a few days here, looks like Mr. Sneed indicates that we are going to dismiss the case. We're not able to locate the victim since it's been about 3 years since the defendant absconded on bond, and we're not able to locate him, so we'll be dismissing it.
The RNO as well?
Yes, Judge.
Okay, so you're newly crossing file number 20-20099FH.
Correct.
All right, and then on file number, okay, all right, so.
So I I'm asking then for a pretrial. Like I said, I have a motion I'm going to finish and file on the newer file. I'm using that word too much, but so just a pretrial schedule for that, if we could, please, Your Honor.
Okay, so my next available pretrial date is September 13th at 8:30 in the morning.
Your Honor,
And then you can,
I'm sorry. I was going to ask if I get that motion. I was wanting to get it done as soon as I can. Is it okay if I schedule the hearing before that pretrial date for the hearing on the motion?
I will tell you that I can do August.
Well, obviously, I don't want to have
Hold on,
hearing
Mr.
on the
Murphy,
same
I'm
day
looking
as
at
the-
something. August 9 or August 30th? Can you get it filed that, well, I don't know if August 9, would you be able to do it in time for that?
Yes, Your Honor. I just obviously don't want to have.
So
one-
I can set the pretrial and you can schedule your motion on August 9 at 8:30.
Yes, Your Honor.
Okay, all right, Mr. Merritt, we will see you back on August 9 at 8:30 in the morning, all right?
Could I have a breakout with my lawyer, please? Just for a minute?
Mr. Murphy, do you have any other cases after Mr. Merritt?
I can talk with him, Your Honor, just briefly, and then I'll talk with him again at the jail when I get over there.
No, I just meant you don't have anything else up this morning in front of me.
Not in front of you, Your Honor, no.
All right, so Mr. Merritt, I'm gonna put you in a breakout room with Mr. Murphy. Joe. Okay, go ahead and join that breakout room.
Thank you.
You're welcome. Mr. Fleming, just for our docket computer system purposes, can you get me a nollie press on that today?
I will absolutely.
You're the best. Thank you.
I know. Thanks, Judge. And while I have a minute, there's ulterior motives as to why I shaved. My kids are very gullible. Granted, they're 5 and 3, but I convinced them that when I go and work outside, that the sun burns off my beard. So I had to keep up the continuity with everything. Shaved it off after I did some work outside this weekend.
So that's like an extreme method to perpetrate a lie. That's awesome.
Absolutely. I'm having fun with it. My 5-year-old kind of started figuring out like, hey, I heard the trimmer's going. I'm like, no, the sun burned it off, bud. But
my husband has a scar that looks like a bullet hole, and so he convinced all our kids that I shot them when they were little.
Perfect. They don't mess with mom anymore, I bet.
No. So I said, well, if I shot him, I'd probably not be a judge. So how?
It was
All right, Mr. Dagermark goes in. I'm just waiting for the jail on your client. I've taken Merritt off the book for that day. So now I just have a really traumatizing civil hearing all day. All right, I have a young man from the jail. What is your name, please?
DeAngelo Williams.
All right, Mr. Williams, let me grab your file. This is in the matter of the people of the state of Michigan versus DeAngelo Williams, file number 22-21133 FH, 23-21308 FH, 23-21309 FH, and 23-21310 FH. I have Michael Dagermark appearing on behalf of Mr. Williams. I have received, July 7th, I received the prosecution's notice of intent to use other acts evidence. And let's see, we have pre-trial no files. So it looks like we have a trial date set. We do have, the jury trial was taken off. Okay, Mr. Dagermark, go ahead.
If I could just explain, and then I'll ask to speak with Mr. Williams in a second, but
Sure.
Procedurally, the case ending in 133 was scheduled for jury trial. I had spoken with Mr. Sneed a few days before the jury trial was going to happen. We came up with an agreement for that case only, that Mr. Williams would plead guilty to attempted R&O, and counts 1 and 2 would then be dismissed. There was an additional agreement that it would simply be credit for time served. He had served, I think, about 8 months or so at that point. So that message was, I don't know if the whole body of that message was relayed to the court, but I know that Mr. Sneed emailed your staff to cancel that trial. The plea was supposed to happen last week. I was out with COVID, so I don't know what happened. But if I can just talk with Mr. Williams real quick, we may be able to handle that right now.
Okay, were there offers made on the other 3 files?
Not at this time, but we are, with each file being resolved, we are getting closer to resolving everything.
Okay, all right, so Mr. Williams, I am going to put you in a breakout room with Mr. Dagger Margosian.
Thank you, ma'am.
You're welcome. So let me close that one jail room. All right, so you're in jail room 3, Mr. Dagger Margosian. Okay, there you go. You should get an invitation to join the breakout room. All right, Mr. Malaro.
Judge, how are you today?
I'm good. How are you?
I'm okay.
All right, so I have he's in jail. I have Bridget Reinhardt in my waiting room.
Yes.
And Miss Adams, Mr. Malaro represents Jade Brown and also Elvin Graves, and they're in custody.
I'm gonna go sign that.
Rio Reed, Judge. I think there's a.
And Rio Reed. So it looks like everybody left. They can just bring in because they're all Mr. Malaro's. What did you say, Mr. Fleming?
I'm gonna go sign that, Nellie. I'll be right back, Judge, on Merritt.
Okay.
If I can get it over to you.
Oh, thank you. All right, so this is in the matter. This is in the matter of the people of the state of Michigan versus Bridget Susan Reinhardt, file number 21-20279FH. I have Salvatore Malaro appearing on behalf of Miss Reinhardt, and I have Christopher Fleming appearing on behalf of the people. Miss Reinhardt, can you hear me?
Yes, I can.
Okay, very good. All right, Mr. Malaro, how do you want to proceed today on behalf of Miss Reinhardt?
Your Honor, we are on the cusp of resolution, but I know this case has been on your docket for quite some time. So at this point, I'm asking that we set this out for a trial date. I don't know how far out you go, but set it for a trial date with a final pretrial in about a month, and I think I would think we could have it resolved.
All right.
Judge, there is a high likelihood of resolution in this matter. I would think that we don't need to clog up the trial docket if we could avoid it. So if we can have a pretrial sooner than later on it.
All right, is that all right, Mr. Malaro?
Well, we're not clogging the docket, Judge, but it's whatever the court prefers. I'm good with.
So why don't we do one more pre-trial date fairly soon? And then if we don't have a resolution, we'll do a trial date. So how about August 30th at 8:30 in the morning?
I like your idea, Judge.
Absolutely perfect. Thank you, Judge.
All right. It's actually Mr. Fleming's idea. You're gonna tell him you liked his idea?
I don't like his idea. I like your idea.
He doesn't like
Okay. All right. So Miss Reinhardt, I'm going to set this for one more pretrial on August 30th at 8:30 in the morning. So you just zoom into the same number you did today. Mr. Malaro, you'll do the stip in order to adjourn.
I will, Your Honor.
And then Mr. Fleming, can you sign your name with permission? I'm gonna say yes. Okay, so Ms. Reinhardt, you're all set. You can go.
Okay, thank you.
Thank you, Ms. Reinhardt.
Thank you. All right, Mr. Malaro, I do have Mr. McFarland.
Yes.
Hi, Mr. McFarland, how are you today? Okay, is he connected to audio? Oh, no. Mr. McFarland, can you hear me?
Yes, ma'am. Can you hear me?
Yes, sir. All right, this is in the matter of the people of the state of Michigan versus Zachary Michael McFarland, file number 22-21053FH. I have Salvatore Malaro appearing on behalf of Mr. McFarland, and I have Christopher Fleming appearing on behalf of the people. And then we also have file number 22-49695PP, which is Megan Marie McFarland versus Zachary Michael McFarland. Mr. Malaro was also appointed on that file for the violation of probation. So we do have some violations of PPO pending as well. So, Mr. Malaro, how would you like to proceed today on behalf of Mr. McFarland?
Your Honor, I've been trying to work out a resolution with Miss Meir, and after I talked to Mr. McFarland this morning, there was another tweak on the offer. If I could have a breakout with him to talk to him about it, I'd appreciate it.
Sure. So I am going to assign Mr. McFarland and Mr. Malaro to a breakout room. And all right, go ahead and join that breakout room. See if we can get a break. Okay, thanks. Perfect.
Good.
Almost done. Close. Okay, so Mr. Williams, I have you back. So I don't have my glasses. I can't do anything about this. Okay, all right. So Mr. Daggermar goes in. Have you had enough time to speak with your client?
Yes, Your Honor, thank you.
And how would you like to proceed today with Mr. Williams?
Well, I guess twofold. On file ending in 133, we are ready to enter a plea to an amended information filed. And then for the remaining 3 cases, I guess what I would want to do is schedule at least one of them for final settlement conference and jury trial.
Okay. Who's your prosecutor on this?
Mr. Sneed, but I think Mr. Fleming is covering for today.
Mr. Fleming, do you have Mr. Sneed's schedule?
I do, Judge.
Today's Wednesday. I actually have Mr. Sneed with me tomorrow. Mr. Daggermar-Gozian, are you available for a bench conference with Mr. Sneed tomorrow at 1:45?
We still show Isaac being off, Judge.
Mr. Sneed has trial tomorrow. Oh, all right. Okay, so I have a Bannon versus Haybecker trial tomorrow, and I had Mr. Sneed on it, so he's not on it.
I do not see that on our calendar, no, Judge.
Miss Adams, is the violation of the PPO trial still scheduled for tomorrow at 2 p.m.?
I still have it on our docket. Is it crossed off in the book?
Nope, so that was scheduled with Mr. Sneed, because I have his name in the book, and it's my writing. So we have that PPO trial notice was sent out and scheduled on the record with Mr. Sneed. for tomorrow at 2 p.m. So I guess I'll probably see you. Is he gone for the rest of the week then, Mr. Fleming?
It looks like it, yes, Judge.
Okay. So how
Actually, he's back
about
Friday, apparently.
he's here Friday?
Yeah.
He's here Friday. Century. Okay, so will he be here next week? Was okay. So does Mr. Sneed and then also you, Mr. Dagger-Margosian, do you have any availability at 11? Let's see. No, it's not that. Miss Adams was gone last week, so I ruined the book, it looks like. District court, sale meeting. Hold on. How about Mr. Dagger-Margosian, is 8 o'clock okay for a time to set a bench conference for you?
That should be, it depends on what day, I guess.
August 9 at 8 a.m.
August 9. That's fine. Yeah, thank you, Judge.
All right.
That should be fine for Mr. Sneed, Judge.
Okay, so file number 23-21308 FH, 23-21309 FH, and 23-21310 FH. I'm going to set for an 8 a.m. bench conference and pretrial conference with Mr. Sneed and Mr. Dagger-Margosian. So, Mr. Dagger-Margosian, can you do this in order to set pretrial on that day for those three?
That's fine.
And then, Mr. Fleming, can you send a note to Mr. Sneed to be available for that?
I already put it on the calendar, Judge. You will
You're the
know.
best. Okay, so that leaves file number 22-21133 FH. So, Mr. Dagger-Margosian, is it my understanding then on that file, your client is going to enter a plea to an added count 3 attempted resisting and obstructing a police officer?
Yes, Your Honor, and the original charges, counts 1 and 2 will be dismissed, and further, Mr. Sneed and I have agreed that it would be a sentence for credit for time served.
Okay, and then Mr. Fleming, you'll provide to the court a amended information adding count 3 attempted RNO.
Will do, Judge.
All right, so write that down. All right, so Mr. Williams, you want to raise your right hand for me? Mr. Williams, there you go. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. You can put your hand down and maybe scoot up a little bit and speak louder for me, okay? Because that room has really bad acoustics, okay? All right, so Mr. Williams, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to a count 3 attempted resisting and obstructing a police officer?
Yeah.
All right, are you satisfied with Mr. Dagger-Margosian as your attorney and the advice that he has given you?
Ma'am.
All right, now do you understand the maximum penalty for this offense could be up to 1 year in jail, but there is a sentencing agreement between the prosecutor and Mr. Dagger-Margosian that you would receive credit for time served.
Yes.
Do you understand that?
Yes, ma'am.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Williams?
Ma'am, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application or leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, so Mr. Williams, how do you wish to plead to the charge on file number 22-21133FH that on or about October 22nd of 2022 in the city of Adrian and the county of Lenawee that you did commit the offense of attempted police officer assaulting, resisting, or obstructing? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty other than what was placed on the record?
No, ma'am.
All right. Do you understand if I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fleming.
No, Judge.
Mr. Dagger-Margosian.
No, Your Honor.
Okay. Is it your own choice to plead guilty, Mr. Williams?
Yes, ma'am, it is.
Okay, so Mr. Williams, on October 22nd of 2022, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
Did you come in contact with an officer, I think his first name is Adrian Robinson, who works for the city of Adrian?
Yes, Your Honor.
Was he in a uniform?
Yes, Your Honor.
Did you, and you knew that he was an Adrian Police Department officer?
Yes, Your Honor.
So did he try to arrest you that day?
Yes, Your Honor.
Okay, and so you're charged with either assaulting or battering or wounding or resisting or obstructing, opposing, or endangering a police officer. That can be any number of things: giving a false name, running for them, not giving them your arm, pushing, pulling, whatever it might be. So when he tried to take you in custody, did you resist him in some way?
Yes, ma'am, I did.
How did you do that?
I pulled away.
Okay, all right. Mr. Fleming, are you satisfied?
Yes, Judge.
Okay. Mr. Dagger-Margosian, are you satisfied?
Satisfied, Your Honor. Thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Fleming?
Yes, Judge.
Mr. Dagger-Margosian?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. And so I know that the plea offer was pleaded as charged, but Mr. Fleming and Ms. Teskey, it's a felony. So Ms. Teskey, can they waive a PSI since, no, I can't waive the PSI. So,
Technically, it's a victim crime. I can't waive the PSI, Judge.
yeah, I know. All right, so Mr. Williams, I'm going to set this matter for sentencing on September 7th at 8:15 in the morning, Mr. Williams. And someone from the probation department, Mr. Williams, is going to come talk to you. So just be truthful with them about your background and also the events that occurred. And they'll prepare a report. We'll provide that to Mr. Dagger Margosian. I understand there's an agreement that you'll receive credit for time served. And then, do you mind appearing via Zoom or do you want to come in person?
In person.
Okay, so I will set that for sentencing in person. And if you change your mind, just let us know. Mr. Dagger Margosian will review the pre-sentence report with you prior to sentencing, and then we'll see you back on that day. All right, Mr. Williams?
Your Honor,
Yes.
if I may just, one last issue, if I can just address bond here. I mean, not on this.
Sure.
Your Honor, I think last week when these cases were in front of you, Ms. Van Duzen had asked to consider a PR bond. I would just bring that request back up. I think it would be appropriate at this point to grant Mr. Williams PR bonds on these cases. As indicated, he spent a significant amount of time in jail on these matters. And there would be no objection to if there needed to be some sort of GPS tether. But I just, I think at this point, it really would be appropriate. I think anything other than that would violate the presumption of innocence. And I think he does have a right to be out of jail to contest these matters.
Mr. Fleming?
I don't know how bond would violate the presumption of innocence, Judge, but I mean, there's been no change of circumstance since last week. People request bond.
Well, I will tell you, Mr. Fleming, last week, the attorney was covering for Mr. Dagger Margosian, and because of the reason Mr. Dagger Margosian stated, so I was not able to fully hear that matter. So they did not have that much information about Mr. Williams. So I know that we have 2 assaults of, let me see here. So he's charged with assault of a prison employee, police officer R&O. And then on file number 23-21309, he's charged with home invasion, 1st degree, assault with intent to do great bodily harm less than murder, malicious destruction of property of a building, assault with a dangerous weapon, and assault of attempted destruction of fire and police. That file carries a maximum penalty of up to 20 years in prison. So he has a potential prison term on that file. And then he's got a carrying a concealed weapon charge and trespass on a different file. And that, let me see, that's November 27th of 22. We got November 27th of 22. Looks like that's a bad day. And February 19th of 23. That could potentially stack. And this file that we currently have is October 22nd of 22. So it looks like 3 files involved the same day. We are, when did I set a bench conference for? August 9th. So Mr. Dagger Margosian, I think that we have a bench conference scheduled for August 9th. So we'll have your client back on that day. And I think depending on what happens that day, we can address his bond again, but I'm not comfortable addressing his bond at this time. I think it's appropriate. All right.
Okay, thank you, Honor.
All right, thank you, Mr. Williams. We'll see you back in about 2 weeks, okay? All right, thank you. So you're all set, Mr. Williams. You can go back. And we're waiting for your next client, Mr. Dagger Margosian. So Mr. Malaro. We're
Your
back
Honor.
on the record.
I'm
Oh,
sorry.
yeah.
I'm sorry to interrupt. I think the only person I have left is Mr. Faithy, but he's out of.
Oh, he's here. I'm sorry. I think I forgot he was yours. I got Mr. Faithy. He's not waiting on one too. Do you need a breakout room?
No.
All right, so Mr. Malaro, back on the record in the matter of the people of the state of Michigan versus Zachary McFarland. We have two files, but Mr. Malaro, how do you want to proceed today with Mr. McFarland?
Well, Judge, as one of the clarifications is you referenced that he was on probation and it's a personal protection order, show cause. But Mr. McFarland has a trial scheduled for August 8th. We are very close to resolution, but I'd ask that we keep that date on. Mr. McFarland has a civil matter tomorrow involving his ex to be that I think will help us perhaps get to the finish line on resolution. So that's what I would ask, if we get this worked out before the 8th. I know the court is amenable to bringing the case in early.
Do you want me to set it? I have enough room for one pre-trial on August 2nd. Do you want me to put it in?
Yeah, that would be a great idea, Judge.
Thank you. So I'm going to set Mr. McFarland this for pre-trial on August 2nd at 8:30. We will mail the notice on the PPO file, but Mr. Malaro, can you do the stipend order on the criminal file?
I can.
All right, so Mr. McFarland, I will see you back on August 2nd at 8:30 in the morning, all right?
Yes, Your Honor. Thank you.
Thank you,
All
Judge.
right, thank you. You're all set. Okay, Mr. Faithy, do you want to, Ms. Adams, if you can let the jail know, we'll take Jade Brown and Elvin Graves and Rio Reed. So in the jail, yep, Jade Brown, Rio Reed, Elvin Graves. Let me get Mr. Faithy's file. I'm sorry, Mr. Dagmar. So this is in the matter. Mr. Faithy, I saw your face. No, he's not connected to audio. So hold on. Send him a chat. Send him a chat to connect to audio. So I've sent him a chat to connect to audio.
Hello,
Hi, Mr. Faithy. How are you today?
I am okay.
All right, and did I pronounce your last name correct or no?
What was that? I'm sorry.
Can you pronounce your last name for me?
Oh, Faithy.
Okay. This is in the matter of the people of the state of Michigan versus Timothy Charles Faithy Sr., file number 23-21219FH. of Michael Dagger Margosian appearing on behalf of Mr. Faithy. So, and Christopher Fleming appearing on behalf of the people. So, Mr. Dagger Margosian, how do you wish to proceed?
Well, Your Honor, here's the situation in this case. In district court, we held a preliminary exam. Subsequent to that, subsequent to bind over, our office has filed a transcript request with the district court. That request was filed months ago at this point, sometime maybe back in March or April. We have been in front of Your Honor at least once, I think a few times, for the purpose of getting new court dates because we still haven't received the.
Can I ask, I have a preliminary exam transcript from January 17th of 23. Is that the one you're looking for?
it may be, we don't have any transcript of any kind. I mean, there only was one.
Right, it was filed with the court on April 6th of 23. And it says that a copy went to you, or no, I don't know if it says a copy went to you. I don't know how they did that down there. But it
Your Honor,
was filed.
Is it the transcript or the request for the transcript? Transcript. Okay, we don't have the transcript itself, and that's what we've been waiting for.
Okay, I don't know what the process is in district court. I would assume one went to the public defender's office, but it's been filed with the court, so.
Well,
I don't know if you need to ask for that, so I think you need to contact Ms. Rees, Earl Rees is her name.
That's fine. Then if that's the case, then we will, because I expect there to be a motion to quash based on an issue that came up in the exam. So obviously we'll need the transcript for that. Then in light of that, then I'll ask for an adjournment of the matter so we can get the exam. Can I ask if the people have the exam transcript?
We just have the order. We don't have the actual transcript.
No, I don't have Miss McGrain anymore. Okay. Well, anyway, so contact Miss Rees and find out why you didn't get it.
Okay, will do. I guess we just need to get a new pretrial date for that.
Okay, so in light of that, doesn't need to be that far away. How about a pretrial date on September 13 at 8:30 in the morning?
That's fine, thank you.
All right, so can you do the stip in order to adjourn? And Mr. Fleming, can you sign your name with permission?
Absolutely, Judge.
All right, I apologize for that. And Mr. Fakey, we'll see you back on that day, all right?
Yes, that was September 13th.
Yes, sir, at 8:30, same Zoom number.
Yes, ma'am. Thank you. Yes, Your Honor.
All right, thank you. So Mr. Dagger Margosian, I think that is all that I have with you.
That's it for me, Judge. Thank you.
All right, thank you. Sorry about that.
That's no problem. Thanks.
What do you have left, Judge?
Who said that? Sarah. Oh, okay, so I have page 1, I have Jay Brown set for arraignment. Page 2, top, Elvin Graves set for arraignment. And then I have Rio Reed set for pretrial. And I don't know what page he's on. He's on page 4.
That's
it? Yep. Oh, who do I have joining me from the jail?
Jade Brown.
All right, Mr. Wait, where'd Mr. Malaro go? I'm sorry, I had Mr. Malaro, now I lost him. Is he in a breakout room with somebody? No. All right, so Mr. Brown, it looks like Mr. Malaro slipped away. So he probably got a call to appear next door. So if you can just bear with us for 1 minute. He should be back.
Okay.
Mr. Fleming, are you texting him now?
Yes, Judge.
Okay. All right. I'm gonna take these files. Oh, there's Mr. Malaro. All right, Mr. Malaro, I'm sorry. I have, what did you say your name was again, sir? In the jail.
Jade Brown.
Yep, I have Mr. Brown, and we have two files. So in the matter of the people of the state of Michigan versus Jade Lejean Brown, file number 2014-17275 FC and 2016-17920. I don't know why. It looks like public defender was appointed to represent Mr. Brown. And there are violations of probation. I don't know why it has your name, but it said you were appearing this morning, Mr. Malaro. So, Mr. Brown, we are here on, let's see, file number 14-17275, an allegation that you violated the terms of your probation and that you engaged in criminal behavior on or about March 10th of 2019, and that you committed the act of breaking and entering, forced entry, or any other criminal act. What's going on here? And then today is the date and time set for a violation of probation pretrial on that one. And then the maximum penalty if you plead guilty or are found guilty on that file. Back there. This is, let's see, attempted larceny of buildings. So you're probably, the maximum penalty on that file should be up to 2 years in prison if you plead guilty or are found guilty. And then on file number 16-17920FH, it's the same allegation of a violation, except on that file, you are on probation for controlled substance delivery manufacturer. Marijuana. And Mr. Stevenson, is that a 4-year? Looks like it's 4-year.
That's a 7-year.
A 7-year. Oh, it must be on the next page. Let me look. Did they must have filed an amended information, maybe? Here. Okay. Must be an amended information somewhere. So, I see it says kilograms, so let me see here. It's gotta be. Oh, there it is. Amended information. So, yep, 7-year. He's always right. Mark that. So, Mr. Brown, if you plead guilty to the violation on this file, the maximum penalty, or if you're found guilty, could be up to 7 years in prison. Mr. Brown, do you understand that?
Yes, Your Honor.
All right. So, Mr. Malaro, how would you like to proceed today on this?
Well, Your Honor, the violation of probation allegations concern a file, a 2019 file that Mr. Brown was just arrested on. So we're going to ask that these matters be set out for pretrial while we deal with that case down in district court. But we would like to address the issue of bond.
Okay, what are the charges downstairs are breaking and entering?
Yes, from 2019, 4 years ago.
Okay, and what's his bond on that file?
Oh, you had to ask that question. So judge's bond is a total, we had a bond hearing yesterday. His bond on that case was a total of $5,000, $2,500 per count, cash or surety.
Okay. And Mr. Stevenson, has he been reporting as ordered?
He has not. He was reporting out of Lucas County in Toledo. He absconded in 2019. May of 2019.
So,
right.
Judge, could I
Mr.
respond?
Malaro?
I'd like to respond to that, if I may. So, Your Honor, Mr. Brown was on probation in Toledo, Lucas County Common Police Court. He was just released from probation there, January of this year. So, if he was not reporting, I don't know why it hadn't been dealt with by this court, because he certainly was reporting down there, and his probation was terminated as completed. That being said, Judge, he lives in Toledo. He hasn't gone anywhere in the last 9 years, it doesn't seem like. I also have received documentation this morning to confirm that he has a medical condition that is actively being treated I don't want to get into the specifics, but it is, I would refer to it as an autoimmune disease that causes a lot of complications. And according to these, the letters and some of the records I have, requires certain medications that I don't think are readily available at the jail. So I would ask the court to consider granting a bond on this that would mirror the bond that he received down in the district court. And he was also, the district court was made aware that he had these pending probation violations. He also, judge informs me, and I have not verified this, but it probably sounds plausible and likely. He has a child that is under the jurisdiction of the probate court in Lenawee County that is subject to guardian proceedings. He indicated to me his judge or his lawyer was Michael Brooks, which tells me it's likely accurate. He has a hearing, I think, what, next week, Mr. Brown?
Next month.
Next month. So there's a high likelihood and high incentive for him to appear in court for these matters while we work them out. So that would be a request with respect to bond on these matters, Judge.
Mr. Fleming or Mr. Bandetto.
Your Honor, I don't have a position as it relates to bond. I'll defer to your discretion.
What did you say the bond was on each file in district court, Mr. Malone?
Judge, the judge imposed reduced the bond to $2,500 per count for a total of $5,000 cash or surety.
All right, Mr. Stevenson, do you have anything further to add?
I did receive some medical documents. The medical documents are dated 2017, 2020 that I received. So this offense would have occurred after those dates, after those diagnoses.
Okay, all right. Do you have any information on why he was released from probation?
Are you referring to the Lucas County case?
I'm sorry. Yeah.
Judge, when I looked at the docket, it said he was terminated from probation in January of this year, and it was completed.
Right.
Which it's been a while since I've been down there, but I think completed would be considered completed.
Successful.
I read that docket as well yesterday, Your Honor. I would agree with Mr. Malaro's representations. When I had clients there, if they were unsuccessfully terminated, the docket specifically said that.
Okay. Mr. Stevenson, any other information?
I do have the absconding details if you want me to read that.
Sure.
Indicates the offender has 2 felony warrants issued 3/15/2019 out of Lenawee County for B&E and larceny. Attempts were made by phone and a home visit to get in contact with the offender, but were unsuccessful. On 4/22/19, this writer contacted the offender by phone, no answer, and a voice message was left instructing the offender to report on 4/25/19. On 4/24/19, the writer received a voice message from the offender stating that he was in the hospital and that he was informed by his attorney that he had warrants. And once he was released from the hospital, he would turn himself in. On 4/13/19, this writer conducted a record check on the offender to see if he was in custody. Vine link for both Ohio and Michigan were checked, and it appears the offender was not in custody, nor has the writer received any update from ICOTS indicating the same. On 5/15/19, this writer attempted to locate the offender at his approved residence of 642 West Northgate, Toledo, Ohio. There was no answer at the residence, so a business card instructing the offender to report was left on 5/16/19. The offender failed to report on 5/16/19, and his whereabouts were currently unknown. That's what resulted in the warrant.
When's your next court date in district court, Mr. Malaro?
It says probable cause hearing, Judge, for July 27th.
July 27th?
Yes, that's tomorrow.
Tomorrow is July 27th.
Yes.
Okay. All right, so I'm gonna set this over to August 2nd at 8:30 in the morning for pretrial next week. And then I will, at this point, I think is bonds appropriate, or I will set bond in the amount of 25,000 cash as surety on this.
That on each file, Judge, or?
Yes. No, let's do 12,000 cash as surety on each file. And then both will be set for pretrial on August 2nd at 8:30, and then Mr. Malaro, I will, by then we should know what happened at the probable cause, and so we can adjust bond further if we need to, all right?
Yes, Judge.
And then you'll do the stip in order to adjourn, or no, we do the notice because they're boxed, so we'll do the notices on those, Mr. Malaro. Thank you.
Thank you,
Mr.
Judge.
Brown, you're all set. Thank you.
Thank you.
Thank
Could you tell him I need Mr. Graves or Mr. Reed next?
Yes, Your Honor.
Thank you.
Oh. Love you.
Hi, sir. What is your name?
Rio Reed.
All right, Mr. Reed, let me grab your file. So this is in the matter of the people of the state of Michigan versus Rio Reed, file number 23-21349FH. This is date and time set for a pretrial conference in this matter. Mr. Reed is charged with home invasion first degree, which carries a maximum penalty of up to 20 years, aggravated stalking, which is a 5-year, interfering with electronic communications, which is a 2-year. And I show the plea offer that was made was home invasion third degree, dismissing counts 1, 2, and 3, and then it would be a maximum penalty of a 5-year. So Mr. Malaro, how do you wish to proceed today?
Your Honor, so Mr. Fleming, that is the plea offer?
That's my understanding. 1 count of home invasion third.
Okay, could I do a breakout with Mr. Reed, Judge? Just to make sure I'm fine.
Mr. Reed, I'm gonna send you an invitation to join a breakout room with Mr. Malaro. Go ahead and click on join that breakout room.
How can I do it? I don't have, oh.
There, you got to find the mouse. Yep.
I got it.
And I'm just running to the restroom. I'll be right back, Judge.
Okay.
Did I hit it?
Hey, Judge,
Yes,
hey, you don't happen to have a person by the name of Jessica in your courtroom, do you?
I have nobody.
Oh, all right, then I guess you do not have someone named Jessica in your courtroom. Thank you.
No, no one came to see me today. All right, let me bring them back. All right, so we are back on the record with Mr. Reed. So, Mr. Malaro, how would you like to proceed with Mr. Reed?
Your Honor, it's my understanding Mr. Reed is going to take advantage of the plea offer of home invasion third, and counts 2 and 3 will be dismissed. I don't think there's a habitual. If there is, those would be dismissed.
No, so there'll be an added count 4 of home invasion third degree. So count 1, 2, and 3 would be dismissed.
That is correct, Judge.
All right, Mr. Fleming, you'll amend the information today to add that count 3 home invasion third degree, or count 4 home invasion.
I will, Judge.
That's a 5-year. All right, Mr. Reed, you want to raise your right hand for me, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, can you state your full name for the record for me?
Rio Reed.
All right, so Mr. Reed, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 4 home invasion third degree, which carries a maximum penalty of up to 5 years in prison?
Yes, ma'am.
Are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
Mr. Fleming?
That is affirmative, Your Honor.
And Mr. Reed, is that correct as far as you're aware?
Yes, ma'am.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
Oh, ma'am.
So, Mr. Reed, how would you like to plead to the charge that on or about March 19th of 2023 in the city of Adrian in the county of Lenawee, that you did commit the offense of home invasion third degree?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am, not at all.
Okay. Do you understand if I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not placed on the record? Do you understand that, Mr. Reed?
Yes, ma'am, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Mr. Fleming?
No, Judge.
Mr. Reed, has your attorney promised you any particular sentence or estimate of what your sentence will be?
No, ma'am, not at all.
Okay. Is it your intention to plead guilty today?
Yes, ma'am.
Okay. All right, so Mr. Reed, on March 19th of 2023, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
All right, and did you enter a dwelling without permission on East Maumee Street, specifically 160 East Maumee Street, apartment 10?
Ma'am.
And when you entered that, an apartment, did you have permission to enter it?
No, ma'am.
What else, Mr. Fleming, is there anything else I need for a home invasion 3? I don't have the statute. in
Either
front of me.
with the intent to commit a misdemeanor or while entering president or exiting the dwelling did commit a misdemeanor or felony.
Would you, Mr. Malaro?
So, Your Honor, Mr. Reed, is it true that you had a protection order not to be at that residence and you violated that protection order?
Yes, sir, I did.
And you knowingly did that?
Yes, sir.
Does that satisfy the court and state?
Who was the protection order for?
Oh, that was a renowned Miss Nicole Quinones.
All right, would you agree with all of that, Mr. Reed, that there was a PPO in place and you weren't to enter that property, but you did anyway without permission?
Yes, ma'am. That's correct, Your Honor.
All right, are you satisfied, Mr. Fleming?
People are satisfied, Judge.
Has the court complied with MCR 6.302 B, C, and D, Mr. Malaro?
Yes, it is.
Mr. Fleming?
Absolutely, Judge.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. So, Mr. Reed, I am going to set this for sentencing on September 7th of 2023 at 8:15 in the morning. Why can I not find you? Oh, there you are. Guilty. So we'll set sentencing on September 7th at 8:15 in the morning, Mr. Malaro.
Yes, if the court would allow, we'd like to address bond on this matter.
I see that he's been in custody since May 1 of this year. So go ahead, Mr. Malaro.
Judge, I have him in for about approximately 5 months. But I would say that Mr. Reed has accepted responsibility for this matter as a Class E felony. I did not run his guidelines, but I probably does not guideline to a prison term. And I know there's no sentence agreement, but we'd ask the court to consider releasing him on a recognizance bond. So he can demonstrate to the court, one, that he can abide by this protection order and stay away from Ms. Quinones when he's not in custody. And two, by appearing in court, showing that he's serious about complying with whatever, hopefully, terms the court would grant, if the court is going to grant any probationary status for Mr. Reed. So in other words, we're asking the court to allow Mr. Reed an opportunity to show this court that he would be worthy of probation, as opposed to any further jail or prison term. So that's the basis for our request for a PR bond, Judge.
Mr. Fleming?
In looking at bond requests, I generally look at the history of the defendant, Judge. I mean, this is his first felony. My concern would be for the victim. I just want to ensure that there is no contact whatsoever. I mean, he was originally charged home invasion first, aggravated stalking, and interfering with electronic communications. Judge.
Hold on, Mr. Reed.
I just want to ensure that there's no contact there, Judge.
All right, so Mr. Reed, listen to me. So you pled to a 5-year felony. So even if your guidelines came down to county jail, if you violate any bond conditions when you're out, I will articulate on the record enough to send you to prison. Do you understand that?
Yes, ma'am, I understand.
All right. So I don't want you driving down our street. Like if you have to go somewhere, drive way out of your way. I don't want you driving in front of her house. I don't want you going to where she works. I don't want you texting her, calling her, Facebooking her, having your cousin Facebook her, nothing. I want zero contact. Do you understand that?
I understand, Your Honor.
And if you do, I will issue a bench warrant and you'll go back to jail. And, you know, it's a serious charge. So you got a really good plea offer, but it is still a serious charge had you been convicted. So I will allow you out on a PR bond with very strict terms of no contact, sir. I mean it. Do not violate your bond conditions. You're not to commit any new crimes, and no contact with the victim. So I will release you on a PR bond. Do you have any questions, Mr. Reed?
Oh, ma'am, I do not. Thank you, Your Honor.
Okay, so I'm going to put you
Judge,
in a breakout. Yes.
sorry, is he gonna be sentenced via Zoom or in person?
Yeah, I'm getting there. Hold on. So, Mr. Reed, in a minute, I'm going to put you in a breakout room with Miss Tusky from the Michigan Department of Corrections. We're on the third floor of the building because it's circuit court and it's a felon. She's going to give you instructions on how to contact her, how to report, and what to do. Make sure you comply with that and you meet with her. I'm going to schedule this sentencing in person, Mr. Reed. All right. If you don't violate your bond conditions, you're probably not going to jail that day. But do understand if you violate your bond conditions, you're going to be going into custody, and that's why I'm making it in person, okay?
I understand.
All right, so that will be in person, and I'm going to put you in the breakout room with Ms. Tusky. When you meet with the Michigan Department of Corrections, I want you to be truthful with them about your background, also the events that occurred. They're going to prepare a report. That report will be provided to Mr. Malaro, and Mr. Malaro will review that with you before sentencing, okay? All right, then go ahead and join that breakout room with Ms. Tusky.
Thank you very much, Judge.
Yep, and you have Mr. Graves as well, Mr. Malaro?
I do.
All right.
Judge, could I do a breakout with Mr. Fleming on Mr. Graves' case before the case gets called?
As long as you don't give him a hard time. He's very delicate today. Look at that face.
No.
All
Mr.
right.
Malaro was very mean to me.
All right.
And I'm
I'm gonna file a PPO later, Judge.
Sure, I'll sign it. There you go. And Becky, if you can let the jail know that I'll need Mr. Graves next. All right, who do I have joining me from the jail?
Elvin Graves.
All right, so hold on, let me close this breakout room, bring your attorney back. All right, Mr. Malaro, we are back in the matter of the people of the state of Michigan versus Elvin D. Graves, file number 23-21428FH. I have Salvatore Malaro appearing on behalf of Mr. Graves, and I have Christopher Fleming appearing on behalf of the people. Mr. Malaro, how would you like to proceed today with Mr. Graves?
So, Your Honor, there was an issue of some videos from the jail. I have received those, but I have not yet had a chance to review them. So I'd ask for a brief adjournment for me to review them. And then I think we'll be in a position to decide either if we're going to set it for trial or enter into some plea negotiation.
All right, so I can set this over to August 30th at 8:30 in the morning. And
Is there any way I can get a PR bond? I'm supposed to get out tomorrow. My other charge that I'm in here for.
so I'm going to set this for pretrial on August 30th at 8:30 in the morning. Oh wait, this is an arraignment. I apologize, Mr. Malaro. So do you waive the reading of the felony information in this matter?
You know, Judge, I'm really sorry. It is an arraignment. I apologize. Yes, we would acknowledge receipt of the information, waive its reading in open court, waive any defects at the time and place of service. Mr. Graves will stand mute, ask that a not guilty plea be entered and a pretrial be set. And we would like to address the issue about it.
All right, so my next bail pretrial is August 30th at 8:30 in the morning. Because it's an arraignment, we will prepare the notice. I'll enter a plea of not guilty on behalf of your client. The charge is possession of methamphetamine, which carries a maximum penalty of up to 10 years. What is he serving time on now? A violation of probation, Mr. Malaro?
Judge, he got a 93-day sentence that began May 23rd. I don't know exact. Looks like it was maybe, I don't know, what was it for? Hold on. I'm not sure.
Mr. Graves, what are you what are you getting out on tomorrow?
Violation of probation.
And what were you on probation for?
Concealing stolen property.
What was it again?
Receiving, concealing stolen property.
Okay, misdemeanor. Okay. Mr. Fleming, do you have any position on this file?
Judge, the allegation here is possession of meth inside the jail. And that seems to be a pretty serious offense. I think there would be at least another felony out of this matter for possession as a prisoner.
Wait a second. He's charged with possession of methamphetamine. There's a new possession at the jail?
No.
Because this isn't
the
at the
possession charge, Judge.
Judge, this is the possession charge inside the jail.
Oh, don't they usually, isn't there a statute under its possession in a correctional facility?
Could be both, Judge. Yes.
Oh, okay.
But
Okay,
I
but that could be just, it was in his pocket when he got arrested. So,
could be,
Is
but they
it-
were in the cell block here.
That's
Snorting
not the
meth,
allegation,
Judge, so
no.
people would.
you guys are talking at the same time and I can't hear anything. What?
Yeah, that's good. It is not, it was possession inside the jail, not when he was arrested, Judge. That's the allegation.
My understanding in reading the report that they were snorting meth in the cell block, Judge.
And he did not bring it into the jail. He's not the one alleged to have brought it in. But as I alluded to earlier, Judge, we have received the videos at the jail. I have yet to review them to see if they comport with what the allegations are.
So I see where, on June 28th of 2025, the district court judge signed bond conditions. And I don't know why they put 25. It's a 10,000 cash surety. So,
Your Honor, we did not address bond in district court.
no, I'm just looking to see what his bond was.
Okay, only because we knew he was under a sentence.
Okay.
Didn't want
All
to.
right, so Mr. Graves, I'm going to release you on a PR bond.
Thank you.
Just wait. Your bond conditions are that you should not use, possess any marijuana, cocaine, heroin, opiate, or any other controlled substance. I'm going to order that you do twice a week drug testing. These bond conditions are all going to stay in place. You're going to do that through Darren Coast in the circuit court. Let's see, they can search your house, search your person. Okay, and I'm going to order that you report when you get out of jail today at 1:30. Like as soon as you get out of the jail, I need you to come to the courthouse. I need you to take the elevator up to the 3rd floor. I need you to check in at the clerk's office and tell them you want to see Darren Coast. He's our probate. Darren, just tell me you want to talk to Darren. He is our pretrial services person and he will monitor your bond conditions. Do you understand?
I do, ma'am.
If you don't show up today before 4:30 to see him, I will revoke your bond again, okay?
Just make sure that I'm actually out of jail because I got court tomorrow and I'm supposed to get out tomorrow.
Oh, wait. So you don't get out till tomorrow?
Right.
Okay. So on your release from jail, if it's during a business day, between 8:30 and 4:30, you need to report to the courthouse. If you get released on a weekend, you need to report Monday morning at 8 o'clock. Got it?
Yes, ma'am.
Okay, thanks for reminding me of that. All right, and then we will see you back. So I'm giving you notice on the record right now, August 30th at 8:30 for pretrial, okay? And when you get out, make sure you contact Mr. Malaro and give him your new phone number, all right?
Well,
So Judge,
All right,
can he do the pretrial by Zoom or does he have to be in person?
you can do Zoom or person. I don't put any restrictions on that.
Okay, great. Thank you.
thank you,
All
Brad.
right. All right, very good. You're all set, and that concludes our criminal docket. Thank
Thank you,
you.
Judge. Have a good rest of the day.
Thank you. Stay out of the sun there, Mr. Fleming.